think we are very close to 6 o'clock.
All right.
I think we have hit that time of 6 o'clock and we start the session.
Sure. Sure.
Good evening and a very warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru in association with Advocates Academy Bengaluru. Today we have with us designated Senior Advocate Supreme Court of India, Sri Shailesh Madiyal, and he has been on this forum umpteen number of times, educating us and enriching on different facets of law. And today he is going to educate us on different judgments as interpreted by the Honorable Apex Court with regard to arbitration. Shailesh, on behalf of Advocates Association Bengaluru and my personal behalf, I extend a very warm welcome to you.
Thank
Over
you.
to you.
Thank you. Thanks. Can I go ahead, Vikram?
Yes, please. Over to you.
Good evening, everyone. First of all, thanks to the Advocates Association Bengaluru and the Advocates Academy Bengaluru. It's a wonderful opportunity for me. Vikram used the word educating all of you. I don't think that is an appropriate word. Perhaps discussing with all of you. I may not be competent enough to educate most of you. Maybe exchanging our views through this forum is a better way to put it. The topic that I would be discussing today is judicial intervention and arbitration with reference to recent judgments. The concept of judicial intervention and to what extent judicial intervention is permissible or the courts have held to be permissible in the context of the Arbitration Act is especially important because the concept of arbitration is largely dependent on the parallel concept of party autonomy, meaning that the parties to a dispute have autonomously decided or chosen to have their disputes adjudicated through the alternate mechanism of arbitration instead of through the court or the normal judicial mechanism. And therefore, when the parties have autonomously decided to have their disputes adjudicated through the arbitral mechanism, through an arbitral tribunal, which could have been chosen by them mutually, the question then arises as to what extent the courts would interfere and to what extent it is permissible for the courts to interfere. As all of you know, initially we had the 1940 Arbitration Act, subsequently by the 1996 Arbitration Act. And one of the important changes that the 1996 Arbitration Act brought about was it substantially reduced the role that courts would have to play in arbitral proceedings or after arbitral proceedings are over. It brought it more in line with the UNCITRAL model law, which again stresses on the reduced intervention of courts. So in the present discussion, I will concentrate on 3 stages at which there is a role for courts to play. And therefore, the question arises as to in what manner and to what extent the courts would play that role. The first is at the stage of Section 8 and Section 11, basically, which is at the time of referring a dispute to arbitration or to an arbitral tribunal. That's the first stage that I will talk about. The second stage that I will talk about is the role of a court under section 34 or 37, essentially a challenge or an appeal against an order of the arbitral tribunal. And the third stage that I will talk about, which I personally, I am talking about this because I came across this in some context and found it quite interesting, which is the role of the court under section 29 capital A bracket 5, which is at the stage of the substitution of an arbitrator if the mandate of the earlier arbitrator is lost because of the period of time having been under 29 capital A having been completed. So I'll talk about the three of these aspects. Let me start straight away with the first, which is the role of the courts under section 8 or section 11. And this is especially in the context of section 16 of the Arbitration Act. So briefly, what is section 8 and section 11? Most of you would already be aware. Section 8 is a situation, contemplates a situation where a party to a dispute approaches a judicial authority, which is a court. A case is filed, for example, a suit is filed before a court. The defendant comes up to the court and says, the court has no jurisdiction because there is an arbitration agreement between the two parties, and therefore asks the court to not decide the matter and instead refer the dispute to the arbitral tribunal. And under section 8, the court, in deciding whether or not to refer the issue to an arbitral tribunal, is required to examine, and you may just note this down because it has some bearing and it would be of some interest, is required to examine as to whether prima facie there is a valid arbitration agreement between the parties. So if the court finds that prima facie there is a valid arbitration agreement between the two parties pertaining to the dispute which is before it, the court would say, sorry, I have no jurisdiction, go to the arbitral tribunal. Similarly, section 11, and especially 11 subclause 5 and 6, contemplates a situation where a party goes to the court, says I have a dispute with another party. However, the dispute is the subject matter of an arbitration agreement. However, since the two parties have not acted in terms of the agreement for the purposes of constituting a tribunal or referring the matter to the tribunal, one of the parties would go to the court and request the court to refer the matter to a tribunal and to constitute the tribunal. That is 11 subclause 6. And 11 subclause 6 has been amended in 2000, or rather 11 has been amended, section 11 has been amended in 2015 by the addition of 11 subclause 6 capital A to clarify that at this stage, where a party goes to a court and says, please refer the dispute to an arbitral tribunal, the court would only look at the existence of an arbitration agreement. And if it comes to the conclusion that there exists an arbitration agreement, the court would refer the matter to the arbitral tribunal. Now, why I was stressing on the word existence is, I'll deal with it as we go along, but please do mark that section 8 uses the word valid arbitration agreement. So prima facie valid arbitration agreement, if there's a if the court comes to the conclusion that prima facie there is a valid arbitration agreement, it would refer the matter to a tribunal. But if you go simply by the letter of 11.6 capital A, all that is required to be seen is there the existence of an arbitration agreement. The court would not, if you simply go by the letter of 11.6 capital A, the court would not look at whether the agreement is valid or otherwise, but simply say that there exists an agreement, therefore proceed to arbitration. How courts have looked at it we'll deal with as we come to the 3 or 4 judgments that I would be referring to. So let us first start with a judgment of the year 2000, which is Konkan Railway Corporation versus Mehul Construction Company, which is 2000 Volume 7, SCC 201. Now, this was initially a judgment of 3 judges. It was confirmed by 5 judges. And then this judgment was overruled by a judgment in SPB and Company, which I will deal with later. But first, let us look at the judgment which is actually overruled. That is Konkan Railway Corporation. The issue in Konkan Railway Corporation was rather interesting. Konkan Railway Corporation dealt with the question as to what is the nature of the decision that the Chief Justice, at that point of time, 11.6 used the word Chief Justice instead of court. Question was, what is the nature of the function of the Chief Justice when an application for reference of a dispute to an arbitral tribunal is filed? Is the jurisdiction of the Chief Justice, whether of the High Court or of the Supreme Court, is that jurisdiction an administrative jurisdiction? Is he exercising an administrative power, or is he exercising a judicial power? The court in Konkan Railway, 3 judges and then 5 judges, held that the Chief Justice is exercising an administrative power. Consequently, what the court held is that because he is exercising only an administrative power, he has to simply, on an application made to him, simply appoint an arbitrator without wasting any time on contentious issues raised by either party. It basically means he does not court, or the Chief Justice at that point of time does not get into the dispute, does not say anything more, simply refers to the entire dispute to the arbitral tribunal. And the arbitral tribunal, of course, can then decide all the other contentious issues between the parties. In this context, the court had held that it is purely an administrative function. And if I may just digress a little bit, interestingly, the court also dealt with the question as to what would happen if the Chief Justice, since he is performing an administrative function, what would happen if the Chief Justice does not act? So the court held that then you can file a writ petition seeking mandamus against the Chief Justice for a direction to act in terms of 11 sub clause 6. Direction to act in the sense of direction to refer the matter to an arbitral tribunal, constitute the tribunal and refer the matter to an arbitral tribunal. So that was Konkan Railway Corporation. Now, although this has been overruled, the reason I started with this judgment is that the underlying principle in this judgment, that is that the court does not get into the dispute beyond a very prima facie examination, kept undergoing change, and the latest judgment now, which holds the fort, SBI General Insurance, the ratio there, if you examine it closely, is very close to the ratio in Konkan Railway Corporation. Although, of course, no court has thereafter held that it is an administrative. All courts have concurrently held that it is a judicial function which the Chief Justice or the court performs under 11.6. But the scope of the examination that Konkan Railway held, that the scope of the examination is very limited, after undergoing change from time to time, has now in SBI General Insurance been pretty much affirmed. We'll come to it without specifically saying so, but if you look at the ratio of the 2 judgments, they are very similar. So Konkan Railway said that the Chief Justice performs an administrative function. This was overruled in a judgment in 2005, which is SBP and Company versus Patel Engineering Limited, 2005, 8 SCC 618. This was a judgment of 7 judges. 6 of the honorable judges took the view that Konkan Railway was not right in coming to the conclusion that the function under 11.6 was an administrative function. So 6 of the honorable judges took the view that the court under 11.6 or the Chief Justice under 11.6 performs a judicial function. Justice Thakkar took a different view, but that was the minority view. Justice Thakkar, in effect, supported the view taken by the court in Konkan Railway. So in SPP and Company, the court took the view that the Chief Justice or his nominee, when an application under Section 11 is filed, would decide at least 2 aspects. One is whether he himself has jurisdiction to decide the issue. On that, of course, nobody could have any quarrel. The second is whether the claim that was sought to be made was barred or whether there had already been satisfaction of the mutual rights and obligations of the parties to the agreement in question. Therefore, if I was today to, rather, if going by the law in SBP and Company, if I was today to make an application, I have an agreement, say, with X, and there's a dispute between me and X. I was to make an application to the court under 11, Section 11, saying that please appoint, there's a mechanism or there is no mechanism, but please appoint, refer the matter to arbitration. The respondent comes to the court and says, no, this dispute might have been there, but we have already settled it. There is a satisfaction of all the claims. Therefore, don't refer it to arbitration. In terms of the law laid down in SBP, the court would enter into that area and determine as to whether in fact the dispute survives or not. This was the second judgment, and therefore SBP widened the scope of the examination that the Chief Justice or the court under Section 11.6 would undertake when an application is filed under Section 11.6. Now, just to pause for a moment, please do look at Section 16. Section 16 provides for very, very wide powers with the tribunal. And it starts by saying that the arbitral tribunal may rule on its own jurisdiction, including ruling on any objections, whether with respect to the existence or validity of the arbitration agreement. So therefore, one could have argued at that point of time that even this aspect of whether there is accord and satisfaction of the claim or not is a matter which the arbitral tribunal ought to have decided. SBP, of course, took a different view. SBP said that the Chief Justice of the court, this is something that before reference has to be looked at, and therefore the Chief Justice can take a look at this aspect. The real widening of the scope of examination under 11.6 came in the next judgment, which was National Insurance Company Limited versus Boghara Polyfab Private Limited, 2009, 1 SCC 267. Now, this is quite an interesting judgment, and this is a judgment prior to the 2015 amendment, which brought in section 11(6) capital A. This is a judgment of two honorable judges. And this really expanded, in my view, the scope of examination under 11 subclause 6. The issue for consideration in that judgment is referred to at para 15 of the judgment. And if I am to give a gist of what the issue was, it was as to in what circumstances a court would refuse to refer a dispute to arbitration when the contract provides for a reference to arbitration and the request for reference is resisted on the ground that the dispute had been fully settled and one of the parties claimed that the settlement was obtained by coercion and undue influence. Therefore, the issue really was as to whether the referral court, which is the 11(6) court, for the purposes of deciding whether to refer the issue to arbitration or not, can and ought to get into whatever limited extent into the merits of the case, which is as to whether there is a satisfaction of the claim and whether the so-called document evidencing the satisfaction of the claim was obtained by coercion or undue influence. The court in this judgment referred to Patel Engineering and SBP and then formed three categories of issues. Category 1, the court said, were issues which the Chief Justice will have to decide before referring a matter to an arbitral tribunal. Category 2 was questions which the Chief Justice may choose to decide before referring a matter to an arbitral tribunal. And the third category was questions which the Chief Justice ought not to decide and which must be left entirely to the arbitral tribunal. The real issue for discussion comes up in the second category, which is questions which the Chief Justice may choose to decide. But in any case, I'll just indicate what each of the categories contemplated. Category 1, which is the questions which the Chief Justice will have to decide, the court said would be questions such as whether the applicant had approached the correct High Court, that nobody can have any quarrel with. If somebody does not approaches the High Court which has no jurisdiction on the issue, then perhaps nobody would say that a reference ought to be made. And the tribunal can't certainly decide whether the High Court has acted within jurisdiction. Within category 1, one more question which the Supreme Court framed in national insurance was whether there is an arbitration agreement and the party applying under section 11 is party to such agreement. So the court said this aspect also the Chief Justice will have to look at. The second category, which the court said are questions which the Chief Justice may choose to look at, not mandatory. So the Chief Justice may very well say that I will not look at it. Let the arbitral tribunal decide this since it has the powers under section 16. But the Chief Justice may look at are questions such as whether the claims are dead or time barred, or questions such as whether the transactions have been concluded and satisfaction has been recorded between the parties. Now, please make a note of this, because on the face of it, these are questions which really get into the merits of a matter. And there is no reason otherwise as to why the tribunal itself cannot decide this. But the court said that when an application is made under 11.6, the Chief Justice may choose to examine this. And the natural corollary to that would be, if the Chief Justice comes to the conclusion that the claim is absolutely dead or time barred, he may choose not to refer the issue to arbitration at all. Or if the parties have already settled, and if that settlement is found to be valid, the court, the 11.6 application may not be allowed at all. The third category, of course, which the court said would not be looked at by, the Supreme Court said would not be looked at by the 11.6 court, the referral court, were the merits of the claim. So merits of the claims, of course, courts have consistently held that merits of the claim are not to be looked at by the referral court under 11.6. But having said that, courts kept widening the scope, as is evident even in National Insurance Company. Now, the two questions which I mentioned earlier, which fall under the second category of national insurance, which is the category pertaining to the questions which the Chief Justice may choose to decide, such as whether the claims are dead or time barred. You may just note this, because this was the view taken much later by the Supreme Court in Arif Azim, which I will deal with, and which was then overruled. So, as I was mentioning, just to give a recap, national insurance widened, according to me, the scope of examination that is permissible under 11.6 by the court to which an application under 11.6 is made. So instead of referring those aspects to the tribunal, the court could look at it itself. Now, this judgment in national insurance came about in 2009. An interesting development took place in 2015. So till now, I was telling you that starting from Konkan Railway, and then SBP, and then national insurance, although courts consistently said that the scope of examination under 11.6 is very limited. In spite of having said that, courts kept on expanding in one way or the other as to what a court under examining an application under 11.6 would actually inquire into. And the last judgment which I referred to, which is this national insurance, actually said that the 11.6 court will even take a look at it as to whether the claim is time barred or a dead claim, or if there has been a satisfaction of the claim made. All this appeared to change in 2015 when section 11.6 capital A was brought in to the statute book. What did 11.6A say? 11.6, of course, said that if there is an appointment procedure has not been followed by either party, the other party may make an application to the court to refer the matter to the arbitral tribunal. But 11.6A said, and permit me to just read 11.6A, the Supreme Court, or as the case may be, the High Court, while considering any application under subsection 4 or subsection 5 or subsection 6, shall, notwithstanding any judgment, decree, or order of any court, confine the examination of the existence of an arbitration agreement, confined to the examination of the existence of an arbitration agreement. So if you simply look at the letter of 11.6a, which was brought in 2015, what did the legislature say? The legislature says when a party comes to the court and says, please appoint an arbitrator, what will the court look at? It will simply look at whether there exists an arbitration agreement between the parties or not. If there exists an arbitration agreement, the court must simply refer the matter to the tribunal, and the parties may take whatever objections they have before the tribunal. That you are aware that power is available under section 16. So therefore, for all practical purposes, the accord and satisfaction test, the dead claim test, etc., which the Supreme Court had earlier set out in national insurance, got legislatively overruled. Because what the legislature said is, don't look at anything else, simply look at whether there exists an arbitration agreement. All other aspects go to the tribunal. This came in 2015. In 2021, the Supreme Court decided the case of Vidya Drolia versus Durga Trading Corporation, which many of you must have already read. This was a judgment of 3 honorable judges. And this judgment arose from a reference made to it, since there was a divergence of views. And one of the aspects which had led to a divergence of views was that some courts had felt that, look, when someone goes to a district court under section 8, saying that this dispute which exists before the district court ought to be referred to arbitration because there is an arbitration agreement, under section 8, the court would look at the question, would have to satisfy itself that there exists a valid arbitration agreement. Whereas under section 11, when an application is made either to the High Court or the Supreme Court, the court has no jurisdiction to look at whether there is a valid agreement, and all that if you go by the letter of 11.6a, all that is to be looked at is, does there exist an agreement or not, whether the question of its validity not being within the scope of that examination under 11. So it led to a slightly incongruous situation where a district court could look at the validity, the High Court or the Supreme Court would not look at the validity, for what in effect is the same purpose, the purpose being reference of a matter to arbitration. So with all of these different views, a reference was made to a bench of 3 judges in Vidya Drolia. I think I gave the citation. It is 2021 to SCC 1. The court in this case held 2 or 3 things. First of all, the court held that one of the fundamental aspects that a court will have to look at before referring a dispute to arbitration under section 11 was as to whether the dispute was in fact arbitrable or not. The court said that there are certain disputes which by their nature are not arbitrable, and therefore such disputes, independent of whether there exists an arbitration agreement or not, cannot be referred to arbitration. The second thing the court said was that there are certain disputes which by their nature are not arbitrable, and therefore such disputes, independent of whether there exists an arbitration agreement or not, cannot be referred to arbitration. Then, of course, the court went into what is an arbitrable dispute. But for the time being, since we are also limited by time, I'll not get into that aspect. You can read that. It's at para 76 of the judgment. But the question the court said that has to be considered is the dispute arbitrable at all? The second thing the court held was that even a question of fraud can be referred to arbitration unless the allegation of fraud is one that would vitiate the document containing the arbitration agreement itself. Therefore, if, for example, I have a claim against Trivikram, and there is I go to the court, or I go to the High Court and say that this is the dispute, this is the arbitration agreement between the two of us. Trivikram comes to the court and says that no, the applicant has been acting fraudulently. Questions of fraud cannot be decided by the arbitral tribunal. If that is his defense, the court would reject the defense and allow the application and say whether the applicant has acted fraudulently or not is a matter to be decided by the arbitral tribunal. But if Trivikram takes the defense that no, I have not signed the agreement itself is forged or fabricated, which means that the constituent document containing the arbitration clause is forged or fabricated, then in terms of para 82 of Vidya Rulia, that is a matter which the referral court under 11.6 would examine. And the logic to that is very clear. If there is no, if the arbitration clause or the document containing the arbitration clause is fabricated, then it would be difficult to imagine that a court would say that the arbitrator would decide as to whether it is fabricated or not. So to that extent, the court would examine the aspect. This is at para 82 of the judgment. Having said all of this, Vidya Rulia once again made it very clear that while under 11.6a, the High Court or the Supreme Court, as the case may be, or under Section 8 for that matter, which normally would be the district court, the court was only to examine the prima facie validity of the arbitration agreement. Therefore, if there prima facie existed a valid arbitration agreement, the court would refer the dispute to arbitration. Now, the very interesting aspect is, therefore, the word existence of an arbitration agreement under 11.6a was interpreted to mean the existence of a valid arbitration agreement. By doing that, the rigors of Section 8 and the rigors of Section 11.6 and 11.6a were harmoniously looked at, and an interpretation which met both ends came about. To repeat just the last part, the word existence of a valid existence of an arbitration agreement as used in 11.6a was interpreted by a three-judge bench in Vidya Rulia to mean existence of a valid arbitration agreement. Now, Vidya Rulia was a judgment of three judges. Of course, Vidya Trolya, the context, just to give you a backdrop, was as to whether a tenancy agreement, dispute pertaining to a tenancy agreement, is an arbitrable dispute or not. So in that context, the court said that even arbitrability is to be looked at by the referral court, but that's not really important in terms of law for the purpose of this discussion. After Vidya Trolya came a judgment of two judges, which is NTPC Limited versus SPL Infra Limited, 2023, 9 SCC 385. I'll not spend too much time on this judgment because by and large, it adopted adopted the test that was followed in Vidya Trolya, or which was referred to in Vidya Trolya. I am only referring to this because of a phrase that was used in this judgment, which is eye of the needle test. This phrase is used at para 25 of the judgment. So the court said that what is to be looked at is the eye of the needle, basically meaning a prima facie view on the existence of a valid arbitration agreement and a prima facie view on the arbitrability of the dispute. Now, something that I must flag. At each stage, the courts kept insisting or stating or holding that the scope of judicial intervention in arbitration proceedings, especially in the context of Section 11 judgments, was very limited. But generally, the nature of judicial proceedings in India have been that in spite of these tests, if courts have found an error, they have interfered. For example, a more commonly used example is in a second appeal. Although in a second appeal, law requires that a substantial question of law be framed, but we all know that if the court finds that something is wrong, then the courts have interfered, holding that a substantial question of law exists. The same is the case with special leave petitions, etc. So it is perhaps in keeping with that, uh, with that manner of doing things, that the courts, while reiterating again and again that judicial intervention is limited, kept leaving it open to the discretion of the courts to interfere if it did find something wrong. And I said this because when I deal with the final judgment which holds the fort today, which is SBI General Insurance, I'll deal with this is Vishwanathan's dissenting opinion over there, but I'll come to it at the end. So after Vidya Trolya came two judgments. One, NN Global Mercantile versus Indo Unique Flame Limited, 2023, 7 SCC 1, and then a reference of the law laid down in NN Global to a bench of 7 judges in the case of interplay between arbitration agreements under the Arbitration Act. That was 2024, 6 SCC 1. NN Global was a judgment of a bench of 5 honorable judges. And the bench, by a majority of 3:2, or just let me just preface that the issue in NN Global was essentially as to whether an arbitration clause contained in an unstamped or understamped instrument can be given effect to by referring the dispute to arbitration under Section 11. And the court came to the conclusion in NN Global that an unstamped agreement was not enforceable and therefore an arbitration clause contained in an unstamped agreement could not be referred to arbitration. But very importantly, at para 163 of the judgment, the court held that the scope of examination of a court under section 11.6 and 11.6a was confined to the examination as to the existence of an arbitration agreement. And what is the nature of examination? It would include examination of the existence of a valid arbitration agreement. So to that extent, the court agreed with Vidyatrulya by bringing in the word valid, but narrowed down the scope of examination by saying that at para 165 of the judgment, by holding that the examination of validity of an arbitration agreement in respect of section 7 should be restricted to formal validity, such as the requirement of the arbitration clause to be in writing, etc. Therefore, in the garb of examining validity, the court cannot delve deep into the question. All that is required is an examination as to whether formal agreement there is it pertains to this dispute, the court would refer it to arbitration. Nothing deeper than that. So although it approved Vidyatrulya, it limited the scope of examination at para 165. And the court also said that while the referral court is only required to examine the existence of the arbitration agreement, the tribunal is required to examine the validity in far more detail. So it made that aspect very clear. Now, since we are a little short of time, very quickly, there was one judgment after this, which is Arif Azim Company Limited versus Aptec.
You may not keep tab on the time. You may
Okay.
take
Okay, because I don't want to exceed your time. That's
all right. That's all right. Please
okay.
continue.
All right. There was one judgment after this, which is Arif Azim Company Limited versus Aptec. Can I have the citation? I'll just give you the citation. Now, Arif Azim came after NN Global and Interplay, and in fact after Vidyatrulya, which had repeatedly now said that simply look at the existence of a valid agreement, and if there exists a valid agreement and if there exists an arbitrable dispute, refer it to arbitration. But Arif Azim said two things. One, it prescribed a limitation, prescribed in the sense of it said that there exists a limitation for filing a 11.6 application, which is all right. I don't want to get into that. That's not really contentious. But more importantly, it also said that if a claim is time barred, hopelessly time barred, then the court would not refer the matter to arbitration. This is what Arif Azim said. This appeared to be contrary to the law laid down in Vidyatrulya and in Interplay, because time barred was not an issue which was to be examined at all, going by the judgments in law laid down in both these judgments. But Arif Azim Company Limited, which is 2024 INSC 155, the neutral citation is INSC 155, said this. So Arif Azim came to be considered in the last judgment on this aspect, on Section 8 and Section 11, which I would be referring to, and this is the judgment which today holds the field, which is SBI General Insurance Company Limited versus Krish Spinning, 2024, SCC Online, SC 1754. In SBI General Insurance, 3 judges of the Honorable Supreme Court held that the ex facie meritless and eye of the needle test, that is, the test as to whether a claim is ex facie meritless or the eye of the needle test as propounded in NTPC, cannot be applied by a court under Section 11. And the only scrutiny permissible is as to the prima facie existence of the arbitration agreement and nothing else. So, if you look at it closely, it really said what Konkan Railway, which had thereafter been overruled on a different point, on the just to give you a recap, Konkan Railway had said that the Chief Justice performs an administrative function. That view was reversed in the subsequent judgments. But Konkan Railway also had said that the scope of examination of the Chief Justice is very limited. That view really, to that extent, is reflected again in SBI General Insurance, which is a judgment of 2024, which said that look only at the prima facie existence of the arbitration agreement and nothing else. To that extent, the view taken by the Supreme Court in Vidya Drolia and NTPC appears to have undergone some modification. But there is a second aspect to Vidya Drolia, which is what I had mentioned was at para 82 of Vidya Drolia, which is that while a question of fraud can be determined by the arbitral tribunal, what if one of the parties says that the very document which you say contains the arbitration clause is a fraudulent document and no such document in fact exists, or it is a fabricated document, or my signature has been forged? Then what happens? While that aspect was not specifically considered in SBI General Insurance, it appears from my looking at it that this particular finding at reasoning at para 82 of Vidya Drolia has not been overturned in SBI General Insurance. I think it's 82 or 78. You can just check up. 78 is what my colleague tells me. Para 78 had dealt with this aspect, and that aspect has not really been reversed or touched by SBI General Insurance. Therefore, the law as it stands today is simply look at the prima facie existence of the arbitration agreement and nothing else. But to add from my end, in my view, the court, if a party takes the view that the document itself is fabricated, the document containing the arbitration clause itself is fabricated, then that is an aspect which the court would consider. So these were the judgments I was referring to insofar as the scope of interpretation under Section 8 and Section 11 are concerned, which is reference of a dispute to arbitration. The second facet of the place under the Arbitration Act where courts play a role is under Section 34 and 37. That is when there is a challenge to an arbitral award or an appeal against certain orders, etc. So please look at section 34. Only two judgments I want to refer to. Sorry, a few more than two judgments I want to refer to over here. If you look at section 34, section 34 says that recourse to a court against an arbitral award may be made only, you may mark this, only by an application for setting aside such award in accordance with subsection 2 and subsection 3. Under subsection 2, certain heads are provided under which a challenge may lie. 34.2a. 34.2b are two other heads on which a challenge may lie, one of which is if the arbitral award is in conflict with the public policy of India. The other heads are not as contentious, so you could go through it. I don't want to spend time on that. Instead, I'll refer to a couple of judgments on 34.2b2, which is an arbitral award may be set aside by the court only if the arbitral award is in conflict with the public policy of India. And therefore, the question is, what is the meaning of the phrase public policy of India? So under this head, I would make an effort to answer two questions. One, what is the meaning of the phrase public policy of India? That is one. And second is, if the court does find that an award is in conflict with the public policy of India, is it open to what should the court do? Can the court modify the award, or is the award required to be set aside in totality? So let us answer the first question first. What is the meaning of the phrase public policy of India? This finds a very detailed answer in Associated Builders versus DDA, which is reported in 2015, 3 SCC 49. This refers to an earlier judgment, which is ONGC Limited versus Saw Pipes, and says that by relying on the ratio in ONGC Limited, says that public policy in India, or a judgment would be contrary to the public policy of India if it is contrary to the fundamental policy of India, the interests of India, justice, morality, or if it is patently illegal. Of all of this, two heads, which is fundamental policy, being contrary to fundamental policy of India and patently illegal. These are two phrases which lawyers such as us have made use of. And any error is, we try to say that it is patently illegal and therefore the court should interfere. But if you look at para 42 of the judgment in Associated Builders, the court holds that there can be said to be a patent illegality if the illegality is such that it contravenes the substantive law which goes to the root of the matter, or if there is a contravention of the Arbitration Act itself, or if there is a contravention of section 28(3) of the Arbitration Act, etc. But as you must have, I mean, the first response of any lawyer would be that these heads are subjective in nature, and therefore there will always be that room for subjectivity in interpretation. And it would, of course, depend from fact to fact as to whether a particular error can be said to be a patent illegality or not. The second question is a little more interesting because it has been the subject matter of more recent determination. The question is, what happens if an award is wrong? is found to be wrong, can the court under section 34 or 37 or the Supreme Court in especially petition or a civil appeal, can it modify the award of the arbitral tribunal, or can it only set aside the award and allow the parties to go back to the arbitral tribunal? The question is interesting because relevant because when we started this discussion, we started with the concept of party autonomy. The parties have, on their own and of their own free will, decided that their dispute will be decided by an arbitral tribunal. If the one view is, if the arbitral tribunal has gone wrong, the courts may under 34 or the other provisions set aside the award. But because parties have autonomously decided to have their dispute settled by the tribunal, the court must refer the matter back to the tribunal and cannot modify the order. The other view was that while a challenge is made under section 34 to an arbitral award, the inherent in the power of a court to set aside an arbitral award is the power of that court to modify that award to the extent it finds erroneous. That was the second view. These views were the subject matter of multiple judgments. And just to list those judgments, one was Tata Hydroelectric Power Supply Company Limited versus Union of India, 2003, 4 SCC 172. This was a judgment of 3 judges. Second was J.C. Budhraja versus Chairman, Orissa Mining Corporation. That is 2008, 2 SCC 444. The third was NHAI versus Hakim, 2021, 9 SCC 1. The fourth was SV Samudram versus State of Karnataka, 2024, 3 SCC 623. You could go through these judgments, but all of this came to a conclusion by the law laid down in Gayatri Balaswamy versus ISG Novasoft Technologies Limited, 25 SCC Online, SC 986. You might have already read it. It's a very recent judgment. Interestingly, the judgment which was the subject matter, the High Court judgment which was the subject matter of adjudication by the Supreme Court in Gayatri Balaswamy, was the very same judgment of the High Court which the Supreme Court in NHAI versus Hakim had found to be incorrect. So to explain this, as I had stated earlier, the question that we are dealing with is, if an award is held to be wrong, is it within the scope of the section 34 or 37 court to modify an award to the extent it is wrong, or does the section 34 or 37 court only have to simply set aside the award and send the matter back to the tribunal? The High Court of Madras in Gayatri Balaswamy had come to the view that it was open to the section 34 or section 37 court to modify an award. This is referred to by a 2-judge bench in NHAI versus Hakim. The High Court judgment is referred to. But a different view is taken. In NHAI versus Hakim, a 2-judge bench of the Supreme Court held that the section 34 or 37 court cannot modify an award. If it finds an award to be erroneous, it simply has to set aside the award and allow the parties, if they so choose, to go back to the arbitral tribunal. But when the Supreme Court decided Gayatri Balaswamy, by a majority of 4 judges, a view was taken that it is open to the court, which is deciding a section 34 or 37 petition or appeal, to modify an award, and therefore, merely because there is an error, the award need not be entirely set aside and sent back to the arbitral tribunal. One more aspect on which there is a determination in Gayatri Balaswamy, but which really was not as contentious at all, because both parties appear to have agreed on this aspect, is that irrespective of whether modification is permissible or not, if a certain part of the award can simply be hived off or simply be cut off, then it is permissible for the court to sever that part and uphold the rest of the award. So these are the two aspects on which, broadly, on which Gayatri Balaswamy decided. But a dissenting view exists in Gayatri Balaswamy. That is the dissenting view of Justice Vishwanathan. The dissenting view of Justice Vishwanathan is in keeping with the law laid down in Hakim. And the dissenting view is also very interesting. The dissenting view says that if you look at section 34, what does section 34 provide for? Section 34 provides for an application for setting aside an award. It does not at all contemplate an application for modification of the award. Moreover, allowing a court to modify an award would amount to the court acting as if it is an appellate body, whereas under the Arbitration Act, it is not expected to be an appellate body. So therefore, Justice Vishwanathan's dissenting view was that if the section 34 or 37 court finds an award to be erroneous, it could either sever, if it is at all possible, sever the erroneous portion and uphold the rest of the award. But otherwise, if there is no severability possible, then the only recourse available is to set aside the award in entirety and send the matter back to the tribunal. Now, I just want to express in 2-3 lines my views on this judgment, because the two views that are expressed. Justice Vishwanathan's dissenting view appears to be a bit of a puritanical view. It is a puritanical view because it looks at a very pure view of what arbitration contemplates. Party autonomy, therefore only the tribunal can decide, and the court can either set it aside or not set it aside. The reality of the situation, however, would be that in India, where sometimes section 34 and 37 applications and appeals, etc., take years together, if an award goes through the entire process and after 5, 7, 10 years, one of the courts comes to the conclusion that a small part of it is wrong but can't be severed, then to say that the entire issue then has to be sent back to the tribunal may not be very practical in the Indian context, especially since it would defeat one of the very important purposes of arbitration, which is the fast and early disposal of a dispute or adjudication of a dispute. This completes the second issue. The third and short issue that I want to refer to, which in the course of a matter which I was doing, I came across and I found rather interesting, is under 29 capital A. 29 capital A is brought in by the amendment of 2015. And before I start this, I must say, I don't have an answer to the question which I am going to pose over here. So this is just some food for thought. 29 capital A fixes a time limit. 29 capital A 1 fixes a time limit within which the tribunal is to decide then or determine a dispute. Arbitral tribunal is to determine. 29 capital A4 says that if the award is not made within the period specified in 1 or the extended period, then the mandate of the arbitrator shall terminate. And 29 capital A 5 and 6 permit the court, the word used there is court, to appoint a fresh tribunal, a new tribunal. Court, if you look at the definition of court under section 2, 2E, 21E, I'll not read out the definition, but it would normally, it refers to the court of original civil jurisdiction. So therefore, by a bare reading of 29 capital A 4, 5, and 6, a civil court could come to the conclusion that the mandate of the arbitral tribunal has elapsed on account of the time not being extended, and therefore we will now appoint a fresh arbitral tribunal. Normal course, there's no problem with this. But a question I ask myself is, what happens when the tribunal itself is appointed under 11.6 by the High Court or the Supreme Court? Under section 11, in some cases, it is the High Court and the Supreme Court which determines the constitution of the arbitral tribunal. So if you go by merely a literal reading of 29 capital A 5 and 6, it would mean there is a tribunal appointed by the High Court or the Supreme Court, but the civil court comes to the conclusion that it has to be substituted by a fresh tribunal and appoints the new tribunal. Now, this issue, to the best of my knowledge, there is some amount of incongruity here. This issue, to the best of my knowledge, has not received determination by the Supreme Court. But I did find 3 different views taken by multiple high courts, which is why I said I don't have an answer to this aspect. And this is just, I'm just flagging it at the end of this discussion by way of food for thought. The one judgment is KIPL Vistacore Infra, which is a judgment of the Bombay High Court, a single judge of the Bombay High Court, which is 2024 SCC Online Bombay 327. And another judgment of a single judge of the Gujarat High Court in Nilesh Ramanbhai Patel versus Bhanubhai, that is 2018 SCC Online Gujarat 5017. Both of which came to the conclusion that if the appointment is made by the High Court or the Supreme Court, the civil court is not the court which can terminate or appoint a fresh arbitral tribunal under 29 capital A, and therefore an application, if an application under 29 capital A4 is to be made by any of the parties, that application would have to be made to the High Court or the Supreme Court, as the case may be, the court which has appointed. This is the view taken by 2 judges. A contrary view is taken by another single judge bench of the Bombay High Court, and that is in Mormugao Port Trust versus Ganesh Benzoplast Limited. And this is in writ petition number 3 of 2020. I don't know if I have the citation. I don't have the citation readily available, but you will get it online. These are available online, which took the view that a court under Section 2(1) is the court of ordinary civil jurisdiction, and it would be open to that court to appoint a fresh tribunal under 29 capital A5, even if the initial appointment has been made by the Supreme Court or the High Court under Section 11. Which one of these is the right view? I don't want to get into. I just flagged it since it's an interesting issue pertaining to the intervention by courts in arbitral proceedings. With that, I come to an end of my part of the discussion. Don't have anything much more to say, and I'm sorry for having taken a little longer than the time allotted to me. Thank you.
Call it education or we call it discussion. Certainly, I can conclude that it has enhanced our knowledge, and especially I would still stick on with the word educate because I don't practice much on arbitration. So for me personally, it has been I would take it as education. You have certainly educated me. Yeah. All that apart, certainly it was an enriching session. And before we conclude, we'll take a few questions, if at all we have any, from our participants. I already see Mr. Anand has raised his hand. Parallelly, I would request the participants to share their questions on the Q&A box. Mr. Anand, I would request you to switch on your video and you can also pose the question. I'm just giving you both the options. Yes, please. Mr. Anand, I'm giving you the option to unmute yourself. Yes, please.
Yes, sir. So thank you very much for enlightening us on the arbitration, some of the sections, major section which are to be considered. And at present, I have a small one question is that when the statute itself will provide the unilateral appointment of arbitration, that particular issue is pending before Justice Nagarata as of now. So in that view, so what is your experience? What is your this thing that when statute itself provide the appointment and it itself appoints an arbitration without giving a chance for the one of the party to choose the arbitrator?
Are you referring, first of all, hi Anand, thank you for your question. Are you referring to the MSME issue?
Not MSME, sir. Right now, the Vivek, I think, one of the matters.
Okay.
Pending
see, because even under the MSME Act, there is a unilateral reference to arbitration.
Yes, sir. Yes, sir.
So that's a good question. I was just thinking about it, in fact. If you look at party autonomy being one of the underlying requirements of referring a matter to arbitration, then there is a problem with that, with the unilateral appointment of an arbitrator, statutory or unilateral appointment of an arbitrator. Having said that, see, you'll have to look at things in the context of how things are in our country. In our country, all said and done, the court, as we were looking at it over a period of time, the courts have played a rather indulgent role even in Section 34 and 37, which is probably because the confidence that people have in courts is still quite high as compared to an arbitral tribunal. So my own feeling is, if, for example, tomorrow somebody is to say that, look, courts will completely stay away. Whatever the arbitral tribunal does is final. A lot of people would not take the risk or would consider it too risky to approach an arbitral tribunal. So in that context, because courts still play a fairly active role, even when a matter is referred to arbitration in the challenge, in appeal, etc. Therefore, and considering the large backlog of cases,
Yes.
in that context, maybe that's the way to go, but it certainly does, on the face of it, fall foul of the principle of party autonomy. To say that unilateral reference to arbitration is permissible would fall foul of the principle of party autonomy. But this is a debatable issue. I mean,
Definitely.
There could be.
In fact, the matter is pending before Justice
Right.
Raghunath as of
In
now,
fact,
which we are waiting.
I in fact did on live law. I was seeing. I think Karnataka High Court has come to has given some judgment on the MSME Act issue also recently. But I could be wrong. This is what I remember seeing. Thank you.
Thank you very much.
Thank you, Mr. Anand. Sir, next we have question by Mr. Philip. Of course, not in the form of a question. He says, firstly, he is requesting for the judgments. Rather, we would share the citations later.
Yeah.
Section 9 of the Arbitration and Conciliation Act also allows intervention of the High Court. Of course.
That's right. Hi, Philip. You're right. It does. I did not get into that because, with the limited amount of time, I just wanted to flag the important issues. But you're right. Section 9 also does allow for intervention of the court. You're right.
Do we have any more questions? You can hit the hand raise button, or you can also post it on the Q&A box. I think that's it for today. Mr. Shailesh, once again, many thanks to you on my personal behalf as well as on behalf of our Advocates Association Bangalore and Advocates Academy Bangalore.
Thanks. Thank you, Vikram. Thank you, everybody. Always a pleasure to be here.
And I am placing the intent. We definitely need one more session on perhaps criminal law.
Sure. Anytime.
With this, we'll conclude today's session. Thank you so much.
Thank you. Bye.